so far. I invite also the audience. Yes, ma'am.
This is an open question to the whole panel. Anyone can answer me. As I heard the panelists saying about a few inefficient people coming up as getting appointed as the arbitrators, why don't we consider a body which is centralized globally, like the Chartered Institute of Arbitrators based in London? And we get the arbitrators appointed by such an institution, because if my information is not wrong, then to become a member of the Chartered Institution of Arbitrators, you have to be a 10 years specialized practitioner, right? So 10 years, I think, is sufficient enough to get the basic know-hows of the expertise. Secondly, recently, Singapore is coming up as one of the major hubs for international arbitration, the institutional international arbitration. The panel's view about that.
Yes. I just would like to say I'm not so much in favor of a central global body, because what I think the beauty of arbitration and the different arbitration centers is that you need to find your specific arbitrator who is well known or who is an expert in the field in the arbitration you have. And if you have a centralized body, I think it becomes very remote. And also, of course, India looks very much to London. I'm, as a German, I'm not so happy about that. Just a little example. You have in the Gulf states, in Arabia, you have basically French law. So it's a civil law system. But via the back door, and not to offend any British here, but via the back door through these financial centers, they introduce now common law. So you have a completely different law system within a law system, which gives, again, fractions and problems. So I think it's much more, in my personal opinion, much better to have different centers, and the different centers then can really see, okay, what kind of dispute we have there, what kind of expert do we need, and then rather show to the parties, okay, we have a list of, we believe, 5 good people, pick one of them. I think that's the better way, in my opinion.
Well, thank you, Oliver. Anybody else like to comment on this?
Two very good points were raised essentially about the quality of the arbitrators and how they should be chosen. And I can only share insights of how it's done in the SISC. And for instance, on our panel, and perhaps that's the way that we should perhaps bear in mind of how it can be done in India as well, that when we have arbitrators on our panel, they're all arbitrators who are accredited. So whether it's from the Chartered Institute of Arbitrators or the Singapore Institute of Arbitrators or any accredited body, they're accredited arbitrators, and they need, in order to even apply, rather than leave aside being appointed, fulfill certain criteria, such as you raised. They need to have a minimum of 10 years of post-qualification experience. They need to have participated in 5 arbitrations, written 2 arbitral awards. And the reason for that is so that they're familiar with the arbitration process, and they're able to draw a distinction between how an arbitration is conducted and how a litigation is conducted, which in the Indian context is very important, because as we heard, a lot of our Indian ad hoc cases, the arbitrators that we appoint are retired judges, and they tend to bring into an arbitration a lot of practices, say, from the courts and the civil procedure. So in order to be able to draw that distinction, you need to have experience in arbitrations to know how it's conducted and how it can be differentiated. Thank you.
Yes, sir. You were first. I'm sorry, I didn't. Oh, okay.
Well, I have 2 questions. First is, like you talked about that labor cases getting settled through arbitration in USA, it's a huge success. Can we introduce arbitration in tax matters? Is it possible? And if it's not possible, what are the reasons? Or we can explore it. That's one. Number 2, we are talking about ADR, about institutional arbitration. I just want to know from Madam Lata Krishnamurthy, what about the possibilities of mediation and conciliation? Have we explored that in the context of settlement of disputes in India, keeping in view the litigation explosion we have?
Mahesh, almost as a routine practice, they refer most matters, especially matrimonial matters, family property disputes, anything to do, even commercial things if it's within the family, most of these go to mediation first. And there is a provision in the same act. The fourth part of the act deals with that, mediation and conciliation. So there are people who are at Delhi High Court is very, very successful for the most part. And many of the civil suits which tend to go on for 20 years get resolved when they are referred to mediation. So it's very much in practice, in use, and it's functioning very well, at least in Delhi and in Chennai.
As a matter,
Yeah. Oh.
Mr. Chairman, I have a question for Madam Lata. My question is that they have referred that this institutional arbitration act is being revised. I want to know whether they are also making any provision that the selection of the institutions may also be there. Because it is very important. We have seen the various institutions have various rules and regulations. And I am just completing my. And second is, there is no provision in the institutional arbitration except the one or two where they make the scrutiny of the awards by the institution itself. If there is any, not the main subject, but otherwise if there is any drawback. And third is that the interest award is mentioned. There is no clause where the interest award is written. Only interest is taken as a very secondary question. It should be interest award because similarly we have seen in the present act, the post award interest is 18%, up to 18%. It lies with the arbitrator, but the arbitrator has a hand to go up to that. Whereas interest high regime has now over, and the Supreme Court has given the also touched the subject in 2014 that the interest award may not be given as 18 as providing there. And similarly, it is also there penalized interest and interest. What they do, the arbitrator at present, they give the one-line interest award. The interest award will be given from the date of cause up to the date of payment. This is also wrong. It should be clearly mentioned pre-suit, penalized, and future interest, so that one-line interest, because the interest varies from time to time, and this may be taken into a very important, and adjustment should be zero. That is my observation.
well, thank you very much, sir. Maybe we first respond to the one question we haven't answered to, and Edgar, you want to do this?
Maybe just a very quick word about tax arbitration, and it's a Swiss perspective, of course. It's extremely difficult to arbitrate a tax matter because, after all, the tax authority have a deciding power, and very often they don't really see the point in resolving the dispute other than through a decision of finally the Supreme Court of Switzerland. So I'm not really aware of very successful tax arbitration in Switzerland. However, what is possible with taxes, at least in Switzerland, and this is also what prevents disputes after all, is you can get, if you have a deal, a corporate deal, for example, that you need to structure efficiently from a tax point of view, you can get the approval of the authorities prior to implementing the deal. So you go to the authorities, you tell them, this is the deal I am proposing to do, and you get their approval, or you negotiate with them the tax status of your operation before getting taxed. So this prevents, in major operations, getting a tax ruling before the operation is really a prevention of the dispute that you don't need to arbitrate after that.
Thank you, Edgar. Any more questions from the floor? Any more observations from the members of the panel? So I think the chairman is now taking over. Yeah. The chairman of all panels.
Chairman. I'm not. Sorry to interrupt. May I invite Jim Duffy to present a memento to our esteemed speaker. Get a first. No. Big no. Yeah.
Miss Lata Krishnamurthy.
Wow, I get one too.
Yeah.
Thanks. Oh, wow.
Someone special from Sri Lanka. She has been regular to our conference and really participating. We met through our common friend. Singapore Arbitration Center. Aditya Gui. Only one. You seem a little bit disappointed. You're just waiting. And the last one, who is this pretty lady? Now I think the next panel is of global investments.